That ticking sound you hear is us waiting for the United States Supreme Court to make its ruling here on Friday morning about whether Lisa Cook is going to be canned on the Federal Reserve as a board of governor. And if she is, then Donald Trump will destroy the independence of the Federal Reserve. He'll grab control of its reins. He'll control its interest rates, and we will be up a creek without a paddle economically. And not only has Lisa Cook filed her final brief late on Thursday, telling the Supreme Court she should not be removed at this moment in time until there is a full hearing and full trial about her due process rights under the Fifth Amendment that she's entitled to, her ability to put on evidence to show she did not commit any type of mortgage fraud, nor is there any for cause to fire her. This is different than all the other agencies and regulatory bodies that the Supreme Court has said to Donald Trump, you can fire everybody at will, but not the Federal Reserve. Well, now the rubber meets the road. All the briefs are in, including a friend of the court brief filed on behalf of Lisa Cook from 32 bipartisan former Federal Reserve chairpeople, stretching back from Reagan through Biden, and members of the Council of Economic Relations, Treasury secretaries, all of one, 32 of them, all have stepped forward and said, do not fire Lisa Cook. Do not give the president the ability to fire at will anybody on the Federal Reserve, especially without due process. That economic ruin will result. We're talking about every living Federal Reserve chairperson, from Alan Greenspan to Ben Bernanke to Janet Yellen, serving 6 presidents from Reagan all the way through Biden, have all stepped forward in support of Lisa Cook. Here is what they said as we are awaiting, because there's no more briefing. All briefing is done. The next report you hear from me on Legal AF Live, on the Substack Live, or here on Legal AF, is going to be the result. Does she get fired and removed from a job she was just in a week ago, voting on rates? Is she going to be removed while she pursues her appeal? Here's what these former former Federal Reserve chairpeople had to say to the court. The independence of the Federal Reserve within the limited authority granted by Congress to achieve the goals Congress itself has set is a critical feature of our national monetary system. But it also creates the opportunity for abuse in service of short-term goals. Insulating the Fed from short-term political pressures is important to preventing such abuse, including attempts to artificially overstimulate the economy or to have the Federal Reserve effectively print money to cover the government's budget deficit. The public's perception of the Federal Reserve as independent is critical, because public trust that the United States will not have very high inflation is necessary both for the Federal Reserve's mandate of achieving price stability and to ensure that the government, businesses, and households can borrow at moderate interest rates. Less independent central banks around the world have at times prioritized such small, short-run gains, resulting in substantial long-term harm and inferior economic performance. Allowing the government to remove a member of the Board of Governors for the first time in the nation's history, while under the cloud of legal challenge, will erode public confidence in the Fed's independence and threaten the long-term stability of our economy. And therefore, they argue she should not be removed, including, as I said, every living member who was on the chairperson of the board of the Federal Reserve Board. Now, what's the argument on appeal? Because she's already won 2 other times. She convinced Judge Cobb, the district court judge, that she was denied her due process because the due process that Donald Trump said she got consisted of one of his lackeys, Bill Pulte, posting a mean social media posting about her, putting up some misleading documents that don't tell the complete story about 2 pieces of property she owns, one in Ann Arbor, Michigan, and the other one in Atlanta, Georgia, one a condo and one a home. They said, she misled her lender, the credit union. She told them that both were going to be her primary residence. That is untrue. Reuters already blew up that story. And it's clear that the credit union knew from Lisa Cook that only the Michigan home was her primary residence and that her Atlanta condo was a vacation home. And she only took the property tax credit in Michigan. Now, there's also new reporting that people in Bill Pulte's life, like his parents, committed property tax fraud. and that there's at least 4 members of Donald Trump's own cabinet, including the Treasury Secretary, who did something very, very similar. The point being is you got to give her due process. She's got to be able to have a hearing. She's got to be able to have a result. She's got to be able to have an appellate process, and then she can prove her case. Because the protection that the Congress gave from the very beginning, from the formation of our country, of the Federal Reserve, was that they can only be fired for cause. Certainly, the Federal Reserve Act says that. And the Supreme Court, as recently as May, in another decision called Wilcox, said you can't fire the Federal Reserve people, certainly the chairperson, without cause. Whereas, by contrast, the Supreme Court has allowed Donald Trump to fire at will every other agency, cabinet level position, department, commission, you name it. It is now going to be chock filled with partisan people, Republican, and when the Democrats take control, they'll take advantage of it and they'll pack it with Democrats. The point is, Congress wanted these very important regulatory bodies like the National Labor Relations Board, the Securities and Exchange Commission, the Federal Trade Commission, the Federal Communications Commission, the Federal Reserve, to be nonpartisan or bipartisan, to make sure that they're doing what's right for the will of the people, not for some partisan consideration, and take them out of the winds of politics. That's gone, except for the Federal Reserve. Why do I say that? Because the Supreme Court in May, in the Wilcox case, said that the Federal Reserve was unique in our nation's history. It was the equivalent of the first or second banks of our United States on founding, the Alexander Hamilton ones, and therefore they were going to allow this protection. And the protection is you got to come up with for-cause termination. Embedded with that is due process. You need to be able to defend yourself against a for-cause termination. They're sort of two sides of the same coin. Now, on appeal, the final brief that just got in on Thursday night, from which Chief Justice Roberts required, is that the argument is that she's not gotten her due process. Don't make the decision now, Supreme Court. Let Judge Cobb hold an evidentiary hearing about due process. There should be due process. Let everybody put on their evidence. And once you're done, we may not even need you on appeal, because due process needs to play out. Now, if the Supreme Court comes back and says, while we're okay with for cause protection for that position to give stability and independence, we're not okay with finding due process rights. I mean, that's an argument of the Trump administration. There's no due process rights. There's no Fifth Amendment rights because she doesn't have a property interest in continuing in her job until 2038. The counter argument is she does. And therefore, if you have a property right and it's being taken away from you, you have due process rights under our Constitution. That's the entirety of the argument. Now, by the time this posts on Thursday morning, we're here on Friday morning off of a couple of filings by Thursday night. We're going to have a result. I don't know if it's going to be Friday or it's going to be early next week. I mean, they've got a little bit of time because the next meeting of the Federal Reserve is going to be in a week before Halloween in October. So they got a little bit of time, but any moment now that the last brief is in, they're not going to do oral argument on this. That's the difference between many differences between a shadow docket and a full-blown appeal. A writ of certiorari appeal, which is how 60 or 70 of the major cases get up to the United States Supreme Court. There's 3 briefs. There's an opening brief, there's the opposition brief, and there's the reply brief. There's oral argument. There's a full record coming up from a development from the trial judge below, and maybe from the appellate court below. Not here. We don't have any of that. We're now down to what's called shadow docket, which is a quick vote of the 9 on the Supreme Court to see if there's 5 votes to grant a stay. Now, they try to argue, well, we're only granting stays. We're really not ruling on the substance. 2 years from now, after we take her out of her job, she can try to get it back. Okay. In the meantime, Donald Trump has grabbed and destroyed the independence of the Federal Reserve. That's the argument. You can't do it now on shadow docket. Shadow docket is 2 briefs, not 3, no oral argument, and a skeletal, incomplete record. It short circuits the deliberation process of the United States Supreme Court. Trump does it on purpose, but the Supreme Court MAGA 6 are complicit in him exploiting the shadow docket. So this is what we're going to see. So I know some people are writing, when are we going to have the oral argument up on Legal AF? There's not going to be an oral argument. We're just going to get a 1-paragraph ruling and a 10-page dissent if it goes the wrong way by Ketanji Brown Jackson, Kagan, or Sotomayor. That has been the model for every one of these emergency applications. 1-paragraph granting of the stay, destroying the career and that particular entity existentially as we know it, and then saying, we'll see in a year or two, maybe on the regular appeal, and then a strong dissent registered by Sotomayor, Kagan, or Ketanji Brown Jackson. That's the format. But let's see what happens. I mean, why did they go out of their way, the MAGA right, in May, in the Wilcox case, which had nothing to do with the Federal Reserve? Why did they go out of their way to say, you can fire everybody, but you can't fire the Federal Reserve without for cause? And implicit with that has to be due process. Because Donald Trump's argument is this ridiculous, for cause is whatever I say it is. It's like rebellion is what I say it is, enemy incursion is what I say it is, war is what I say it is, and I can't be challenged. But how is that any protection? If the Supreme Court wants to give the Federal Reserve protection, which they obviously do, how is making Donald Trump just say out loud, that's the for cause, you can't challenge me, you can't review it? How is that any protection to the independence of the Federal Reserve noted by the Supremes? Keep an eye here on Legal AF and also on Legal AF Substack, because as soon as there's a report, I'm going to jump on Substack Live and tell you all about it. Hit the free subscribe button here, hit the free subscribe button on Legal AF Substack, and become a paid member as well. So until my next report, I'm Michael Popok. I'm Michael Popok, and I got some big news for our audience. Most of you know me as the co-founder of Midas Touches Legal AF and the Legal AF YouTube channel, or as a 35-year national trial lawyer. Now, building on what we started together on Legal AF, I've launched a new law firm, the Popok Firm, dedicated to obtaining justice through compassionate and zealous legal representation. At the Popok Firm, we are focused on obtaining justice for those who have been injured or damaged by a life-altering event, by securing the highest dollar recoveries. I've been tirelessly fighting for justice for the last 35 years, so my own law firm organically building on my Legal AF work just feels right. And I've handpicked a team of top-tier trial fighters and settlement experts throughout all 50 states known as big auto injury attorneys who have the know-how to beat heartless insurance companies, corporations, government entities, and their attorneys. Big Auto's attorneys working with my firm are rock stars in their respective states, and collectively responsible for billions of dollars in recoveries. So if you or a loved one have been on the wrong side of a catastrophic auto, motor vehicle, rideshare, or truck accident, suffered a personal injury, or been the victim of medical malpractice, employment harassment or discrimination, or suffered a violation of your civil and constitutional rights, then contact the Popok Firm today at 1-877-POPOK-AF or by visiting my website at www.thepopokfirm.com and fill out a free case evaluation form. And if we determine that you have a case and you sign with us, we don't get paid unless you do. The Popok Firm, fighting for your justice every step of the way.